We will go on the record in the matters 24 CF 219, 25 CF 09, 25 TR 30, State of Wisconsin versus Austin Russ. The state appears through Assistant District Attorney Holly Rockow, Defense Counsel Eugene Harrington, and Austin Russ, all in person. We're set today for status conferences and a preliminary hearing. Off the record, Defense Counsel indicated this will be a waiver of a preliminary hearing. Is that
all right? Right here's the critical moment. Waiving a preliminary hearing isn't something to take lightly. The defendant's basically saying, I'm okay if the state moves forward without all the usual scrutiny. It's a big step, and the judge makes sure he fully understands the rights he's giving up. Ever wonder why preliminary hearings matter so much? Drop your thoughts, Bella.
Correct, Mr. Harrington?
That's correct, Judge.
Officer is released. Mr. Russ, do you understand what it is to have a preliminary hearing?
Yes.
The burden is on the state to prove a felony was probably committed, and it was probably committed by you. Do you understand that?
Yes.
Do you understand that by waiving your right to a preliminary hearing, you are agreeing that the state can at least meet that burden?
Yes.
You understand at a preliminary hearing, your attorney would have the right to cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence against you. Your attorney would also be able to produce evidence on your behalf or possibly discover things about the case which could include defenses. Do you understand that by waiving your right to a preliminary hearing, you're giving up those rights for this hearing only?
Yes.
Do you understand that if the state does not meet its burden as to the felonies, I could amend them to misdemeanors or dismiss them altogether, but you're giving up that right today?
Yes.
Do you understand that as a result of waiving your right to a preliminary hearing, this matter will be bound over to future proceedings, which could include a trial?
Yes.
Do you understand that once you give up the right, it is forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing.
Yes.
I will find that you are competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and find the matter over. Information, Ms. Rockow.
Your Honor, I'm just filing it now. It mirrors the charges contained in the criminal complaint.
Proceed with an arraignment or set for another date.
Today.
He understands charges and maximum penalties.
Yes, Judge.
Waives formal reading.
Does.
Not guilty pleas.
Yes, Judge.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Are you still on Oak Street West, lot number 29?
Yes.
Telephone still ends in 1558.
Yes.
May we still continue to send you text message notifications?
Yes.
All right. Would you like to set this for a status conference sometime in the near future, Mr. Harrington?
Yes, Judge.
Let's do your March 24th at 2 p.m. March 24th at 2 p.m.
That's the same time as PAPL. You want to stack those?
Yes.
Or
I'm not stacking Winquist, but I'm going to stack the 2 p.m. All right. Well, we will see you then. Bond continues.
thank you, Judge.
Thank you.
Richie is going to be a waiver. Actually, sort of, we have that case resolved if Mr. Richie shows.
We will go on the record in the matter 24 CF 244, State of Wisconsin versus Ronald Ritchie. This state appears through Assistant District Attorney Holly Rockow in person. We have Eugene Harrington, Defense Counsel, in person, along with Mr. Ritchie. We're set here today in this matter for a preliminary hearing. How is this matter proceeding, Mr. Harrington?
Ms. Rockow, go ahead.
Your Honor, this won't be a preliminary hearing today. The state is moving to dismiss count one, the sole felony in the criminal complaint. I believe that we're moving towards a resolution. I don't believe that the state can prove that count, and therefore I think it's appropriate at this stage to simply dismiss that. The state's going to gather some additional information via law enforcement and the victim. There may be an amended criminal complaint filed, but for now, the state is just proceeding on count two.
All right, thank you. And now,
The court just dismissed count 1 burglary charges gone for. Now, this happens when the prosecution feels the evidence just isn't strong enough to hold up. But don't get too comfortable, because the story's far from over. What do you think? Did the defense get a break, or is this just a strategic move by the
I'm looking at count 1, burglary of a building or dwelling, and that alleges on or around November 23rd, 2024, that the defendant intentionally entered a dwelling owned by RB without the consent of the person in lawful possession of that place and with intent to steal, quote, heat, end quote. And so that's the basis for the request to dismiss.
Yes.
The court will grant that motion to dismiss. Therefore, we do not need to have a preliminary hearing in this case, and the matter appears to be working towards a resolution. We do have $250 cash that has been posted as bail. I do not have any request or anything notifying the court that I don't have a victim key identifying who the victim is, nor do I have any restitution supplement identifying if there's any restitution being requested. And the court's going to need to know those things before we move towards a resolution. Mr. Harrington, looking at this case and a potential possible resolution, are you looking at getting the matter set for a potential plea and sentencing or just a status?
Plea and sentencing, what Ms. Rockow and I are talking about, then I have to go through with
Now we're moving into the timeline shelf resolutions might take until the end of March or even April. Al, that delay might seem frustrating, but it's pretty common when restitution and evidence valuations come into play. If you were the defendant, how would you feel waiting that long? Let me know your take in the comments.
Mr. Ritchie is the amount of restitution. Ms. Rockow and I chatted in the hallway about she's going to get an inventory of the property. I need to go through that with Mr. Ritchie and calculate the value and then come up with some final resolution, although I really think we're going to get this resolved, Judge. It's just a matter of some details that Ms. Rockow and I need to deal with. I'm not so sure we're going to be able to get this done by the 24th of March, though. Oh, like this.
Do you think it could reach resolution by April 2nd? Run outside. Run outside. Like run. Run means run.
I note that I will be here on March 31st on Roseland status conference.
I'm fine putting it on March 31st if you believe that it could be a potential plea and sentencing.
More likely than that day than the other day, the week before.
All right, how about 2 o'clock on the 30, not 2 o'clock, sorry, 2:30 on the 31st. We will schedule it for a plea and sentencing. Hopefully it can reach resolution by then. If not, we'll just reschedule for another date. But again, there's $250 posted. So if there is restitution, that would first go towards restitution before it goes towards court costs and fees.
Clerk will give you a notice. You want to wait outside just a couple of seconds?
Mr. Ritchie, is your address still on Johnson Street with P.O. Box 125? Is that a yes?
Yes.